Thank you, Mr. President.
Gracias.
And we will do our utmost to fix the demonstrative and resubmit it in accordance with the procedural order, and that should satisfy the respondents, I'm hoping.
Buenas tardes, señor presidente. Listo.
Good afternoon, Mr. President. I am ready.
Very good. Well, I think we have no administrative business to tend to, and if not, we will return immediately to the examination.
Thank you, Mr. President.
On the record, I have seen internal documents that you received from OGGS and that shows who was in charge of this. I understand that the two persons that were in charge of this issue were reported to you while you were the director. They were Milton Leon and Cesar Ulloa. Upon reviewing the documents, I did not see anyone else who was sending written communications, correct? Yes, correct. As a matter of fact, they were the ones that were in charge of this conflict, and you led it as the director, correct? There were other support specialists, Victor Vargas and Mr. Daniel Amaro. That was the team that always facilitated the dialogue processes. But the two main individuals in charge were Milton Leon and Cesar that reported to you, correct? Correct. And decisions were made jointly between the three of you while you were in charge of the office for the management of citizen participation and dialogue, right? Could you please repeat the question? Of course. The decisions made in connection with this conflict, were they made jointly among the three of you, or was it you the one who made the decision? When you're talking about decisions, are you referring to agreements, something like that, or administrative decisions? I'm talking about decisions as to how to proceed in connection with this conflict, whether there was a need to continue with the dialogue or not, for example. Well, the actions to be followed were assessed, and did the three of you do it in a committee? Was that the way a decision was reached? Yes. However, and to be a little bit more specific, however, throughout the negotiation process, had their degree of flexibility to carry out the dialogue process. And I understand that Mr. Milton Leon was the specialist in charge. Therefore, he was the one who had the greatest flexibility or freedom, correct? Yes. Mr. Trigoso, OGGS had several meetings in the second half of 2018 with Paran and Lupaka. I think it was up to the end of the year. There were several meetings. There were some more in 2019, but let us first look at 2018. In your first statement, you say that after the blockade of October 2019 at paragraph 34, the specialists attended meetings in the area. And then you state at 34, in exercising my role, or while I was in office at the OGGS, I had the opportunity to participate in several of these meetings, and I also participated or exchanged communications with the Peruvian community in Invicta to mediate a resolution to the conflict. In 2018, did you attend any meeting with Peruvian? To be clearer, these were not joint meetings. They were preliminary meetings with some managers or some representatives of the mining company. In 2018, I did not have any meetings with them because I was just starting with my job as head of the Dialogue and Citizen Participation Office, and that was just in October 2018. And it was just when we started with some joint actions with the higher management in January 2019. And here I would like to specify this chronology because it is important, Mr. President. On January 20th, I had a meeting at the request of Vice Minister in Chaustegi with the manager of Invicta Mining and the CEO, Mr. Well, I am sorry, but I'm asking you about this. First, we're going to look at 2018, and then we're going to look at 2019.
I believe the witness was trying to provide an explanation in response to the question, and he's being cut off by claimant's counsel.
I know, but I think the witness may have gone a little afield from the question that was asked. Let's Mr. Trigoso, let's focus on addressing the specific question that is asked, and then if there are additional points to be raised, you'll be asked as well questions by counsel for respondent, and at that point you can offer whatever additional detail you think is appropriate. Is that acceptable to you, sir?
Sí, señor presidente.
Yes, Mr. President, I was just doing it to offer some context and also to elaborate my answer. But if you think that it is proper for me to give an answer that is more brief, I will do so. So in connection with the question, Mr. President, if you allow me to answer. May I answer? Thank you, Mr. President. Yes. So your question again, would you please repeat your question so I can give you a brief answer? Certainly. As to the meetings, up to late 2018, I understand that you were not present in the meetings with Paran or the Invicta representatives, correct? Correct. But I understand that in the weekly meetings held, that you were explaining the contents, and these were meetings in which you saw some PowerPoint, and there you got a summary of the meetings with Paran and OGGS, at least as of October 2018. That is when you started to work as director. And I understand that you understood that throughout those meetings, the OGGS urged the community to lift the protest, to put an end to the protest. Yes, that is part of the documents that we presented to the community. The documents that you presented to the community, that is to say, are you talking about letters? What are you talking about? Yes, communications. And also, did you urge the community not to have a dialogue while the blockade continued? Those were instances in which we urged the parties. Yes, again, we urged the parties. And for the last meeting of 2018 held on November 21st, the community committed to consult on putting an end to the protest in their assembly on the upcoming days. Do you recall? I recall that because of the documents I reviewed. And in early December, Peru reported that they were not going to come to an end with that protest. Correct. With that, there have been several meetings from the blockade in which OGGS has urged the community to put an end to the blockade, and this proposal has been rejected, correct? Yes. Now, let us move on to the meeting held on January 29th, 2019, also coordinated by OGGS. I understand that this was the first meeting in which you participated with Peran and Invicta. Is that correct? Yes. And you were there with Mr. Leon, correct? Yes, I was there briefly with Mr. Leon, and then Mr. Leon stayed behind with part of the team to facilitate the process.
And the idea of the meeting was that it be agreed to formally establish the dialogue roundtable. Is that right? Well, that was not necessarily as part of some points. The idea was to establish a common agenda as between the parties. That was the purpose of the meeting, because we considered, Mr. President, that each party should come with its positions, and those positions had to be translated into a common agenda so as to initiate a dialogue process. That was a preparatory meeting, that's what we called it, so as to be able to come to agreement on agendas and begin a dialogue process and definitively establish the dialogue roundtable. And that is why in that meeting no minutes were signed, nothing was agreed upon, because one of the parties did not accept the conditions of the points on the agenda. Before moving on to that last point, I understand that from the OGGS, once again, the community was being urged to lift its protest so as to be able to proceed to dialogue. Correct. And the community refused to do so. That's right. And at that meeting, I understand that Paran put forward a claim saying that its lands were affected by contamination, mostly because of an impact generated by the company, they said. There was a prior document that they presented as well. What are you saying? What are you referring to when you say impact? General impact. I'd like to ask for a more specific response. What do you mean by a general impact? Impact of the mining activity. And was that related to an environmental problem? Environmental impact, social impact, the impacts that mining activity can have. Now, no, these are initial points for negotiation. Not all of the points of negotiation are part of a final agenda. And these impacts, which I understand, that was the main subject of discussion, correct? Initially, I could say that it was one of the points for unifying the agenda, because the agenda was yet to be defined, had yet to be defined, nor the items to be addressed. Let's turn to the draft agreement. It's at tab 35. This is Exhibit C346. And I understand that these are the minutes that were drafted as of that time, or 344, rather. It's C344.
We're at, the record says it's a tab 35, and at tab 35 I have another document. Is it tab 36 we're looking for, or what?
C344.
I understand. I'm trying to find where it is. 35.
Is it? Sorry, 35. My apologies, sir.
Okay, 35 is C344, yes.
Thank you very much
Okay.
for that clarification. Y allí,
And there, one finds a description of the points of discussion, correct? Yes, 3 agenda items were established, initial agenda items. They're there. And then, under item 4, well, it's 3 agenda items, not points of agreement. Yes, thank you. And then, in terms of the agreements, we see at point 1 that it is agreed that the parties agree to formally declare the dialogue between the Paran community is established. The second is a formality. The community will deliver the number, name, and accreditation documents. 3 is similar in addressing Invicta, doing the same. And the fourth point of agreement is a much more substantive issue. It says that the Invicta Mining Company, together with the Paran community, will carry out the identification and location of the possible damages to the lands that the community refers to within the mining components located within the territory of the Paran community. And for that, a representative of the OEFA will go. Do you recall that point? And the representative of the OEFA is an agency in charge of environmental monitoring, correct? No, that's not right. The OEFA has other functions, is environmental supervision and inspection. In other words, what Paran was asking for here was that there be supervision and inspection by the OEFA, correct? No. You're signing something that hasn't been signed. The agreements were not signed, therefore they're not valid agreements. Therefore, allow me please, with your permission, Mr. President, to conclude answering the question. Of course, go ahead. The agreements weren't signed. That's why the minutes weren't signed, and therefore, well, there were discrepancies So as between points 4, it was mostly that because of that one of the parties didn't want to sign the agreement. So we don't consider this agreement valid because while one of the parties can come forward with a proposal, the other party did not accept it. And so the agreement came, there was a debate and no agreement. There was no agreement, there was no consensus, and therefore the agreement cannot be considered an agreement. And mindful of this response, it appears that building a road was not included on the agenda, correct? As I say, the only thing that was established were the points of the agenda. There were 3. And so the 6 points of agreement were not put forward. So I would not venture to give you an answer in response to your question. Thank you, Mr. Rodrigo. So I'm asking you because you were there at that meeting, and I wasn't. As I told you, Mr. Attorney, or through you, Mr. President, I was here at the beginning of the process. I was an official who had other functions to perform, and therefore we left the specialists to develop this dialogue process. And during the time you were at that meeting, was the issue of the road discussed? I can't say because I wasn't there. Not at all? No. When the agenda items, when the 3 points on the agenda were discussed. While there are agreements, these agreements were not signed. And I can't tell you exactly what happened during the discussions because I wasn't there. So let us now look at the letter from Paran that made reference to this meeting. That is at tab 53. And it is a letter from Paran dated 12 February. To the Minister of Energy and Mines, as I understand it, or at least a representative of the Ministry of Energy and Mines, Mr. Francisco Ismodes. And here it explains the reason why, according to Paran, they did not sign this agreement. And it says, about halfway through the second paragraph, that on 26 January 2019, a dialogue table was installed, which took place on that day, taking the 5-point agreements, not reaching agreement on point 4 between the community and the representatives of the mining company Invicta. That dialogue was suspended. And then he asked for another meeting on 19 February.
Exhibit R13.
And looking back to this letter, it says about halfway through that there were 5 points that agreement was not reached on point 4 between the community and Invicta, with which it appears that no specific agreement was reached on precisely how this point 4 was to be drafted. Would you agree with that reading? Well, what I agree with is that there was no agreement on point 4. The reasons why there was no agreement on that point, I cannot say. But there was not agreement with respect to point 4, and this resulted in the community not signing these minutes. And do you have personal knowledge that at this meeting, Paran requested compensation of $2 million? And do you have personal knowledge, based on the reports that came to you, that Paran demanded compensation of $2 million as compensation without justification at this meeting? Reviewing the documents, yes, there is information. I can't tell you where it's to be found. But yes, they were asking for compensation. And I need to state this clearly, Mr. President, that sometimes the communities have perceptions of negative impacts not only on their environment, but also on their uses and customs. And in response, they propose some sort of compensation without any technical foundation. So we do believe that it is valid for one of the parties to have an expectation, and that must be respected. But it's in the agreement that that is debated and supported, and then the parties make the decisions, not the state, not the Ministry of Energy and Mines, but the parties. Of course, at any rate, did this demand seem reasonable to you? I can't pass any value judgment about the valid claims of any of the parties. What we do is, well, we try to raise awareness and bring the parties together and have them be the ones to debate their proposals within the framework of mutual respect, in the framework of good faith, and other procedures that we promote in order to establish dialogue mechanisms. But at any rate, I understand, based on your previous response, that there was no technical support for demanding this compensation. That's right. You know that there must be technical support for any compensation in order for it to be paid. It's not simply a perception that I want someone to make reparation to me for some harm. And as we can see from this letter, they asked for a meeting on 19 February. Do you recall having read this letter? Yes, I read that letter and I answered that letter. The letter is at C091. It's 028. Yes, let's take a look at that letter. It's at tab 20 of your binder, and it is exhibit C191. And that letter sent 18 February to the community of Paran, to its president, to be more specific, and it begins by saying, "It is my pleasure to greet you," and reply to your request to continue the dialogue. to be facilitated by the OGS. It was unilaterally suspended by a decision of your client. That's right, that's the truth. So it was Paran that decided to suspend the dialogue on 29 January. When there are no discrepancies on a point, like the discrepancy at item 4 of the agreement that was not signed, one of the parties can state their inconformity and not sign the document. On not signing the document, the meeting is suspended, so as to find other moments to meet. It's not that the dialogue is shut down, rather it's suspended within the spirit of trying to persuade the parties and then pick up on the dialogue once again. The policy of the sector is always to maintain the dialogue as an instrument for facilitation, an instrument for bringing the parties together and solving these disputes. I understand here you are saying suspended unilaterally by decision of your client. Yes, that's right. What this word unilaterally evokes for me is that Invicta was willing to continue that discussion and that Paran interrupted that discussion that day on 29 January. Can you confirm this? Well, let's see. What I was told by the specialist is that it wasn't in agreement with the drafting of item 4 of the agreement. On not being in agreement with one of the points being debated, they didn't sign the minutes. On not signing the minutes, well, that implies that the dialogue could not continue at that time. Other mechanisms had to be sought to try to bring the parties together in order to agree upon a new agreement. And do you recall the point of the drafting? No. The letter continues, and it says, in this regard, is it important to mention that after transferring the communication to the company, and here I pause, in other words, when you issued this letter, you have discussed with Invicta the response to the letter from Paran that we saw earlier. What we, as I mentioned earlier and throughout my statement, the sector, through the Ministry of Social Integration, sought dialogue to resolve disputes. So we invited the parties. We said, what's going on? Why don't we adjust the agreement? We would urge them to find consensus. And also, we, through the specialists, spoke with representatives of the company, and they gave us the possibility of continuing the dialogue. They agreed, since the community had notified the ministry that it wanted to go forward with dialogue. And the letter continues. It says that the undersigned considers it advisable to continue the dialogue, but with the following conditions, : the dialogue should be established in equal conditions and on the basis of social peace. And there I highlight that it says should be or must be consistent with public order. In this sense, such continuation will be exercised without any coercive measure. In this context, the next session will be convened immediately after verifying that there's no blockade in the area or resistance from the population against the company. So let's take a look at this.
Señor Gallegos,
According to the transcript, you have referred to the following conditions, reading the document, but the document says considerations, not conditions. Excuse me, Mr. Grane, for that mistake. The following considerations, correct. So I'm struck, as I have already noted, that the dialogue must be established on equal terms without any coercive measure. And it also strikes me that it says that the next session of the dialogue will be convened only after verifying that there's no blockade in the area or resistance. And what I was noting is that it says that first the blockade should be lifted and then the dialogue can go forward, correct? Correct. But this, Mr. President and members of the tribunal, is, as I had mentioned, an appeal made by the sector to one of the parties. It's not a condition per se that yes or yes, because the work of the ministry, perhaps the office of the General Office of Social Promotion, is to continue the dialogue to resolve the dispute. To renounce the dialogue would be renouncing our sectoral functions. But here it uses imperative language. It says that it must be on the basis of social peace and public order without any coercive measure. It's very clear that in this letter you're conditioning the dialogue on the lifting of the blockade. It could be that you're urging or appealing to the parties, but you're telling them that as an agency, you're not going to mediate in that dialogue unless the coercive measures are lifted, right? Let me reiterate. It is an appeal because the Ministry of Energy and Mines does not have any coercive competence so as to be able to demand the lifting of any measure, because we, as Ministry of Energy and Mines, do not use force as part of resolving social conflicts. I understand. But you're saying that we as OGGS, we are not going to continue to mediate if these coercive measures continue. Yes or no? It's not what you're concluding, sir. We here are issuing an appeal. An appeal is a request that we make. And as I say, and I reiterate, because we could not imperatively say, lift it, because we did not have the function of being able to take the initiative for lifting a coercive measure by bringing in official forces. That's not what I'm saying. What I am asking you is, what is it that you were saying in this letter? And I am proposing that what you're saying in this letter was that as OGGS, you were not going to continue participating in the mediation until such time as the coercive measure were lifted. Mr. President, as I say, here we are urging, and the one who can express the spirit of the letter is the one who's drafted it. That was the aim of what was written here. We urge them to lift the coercive measure, because for me to say if you don't lift it, then I won't engage in dialogue, then I would be renouncing the very essence of the Ministry of Energy and Mines by not facilitating a dialogue. Let us look at the next page of this letter, where, in effect, in the first paragraph, the word urge is there. And it says, we urge you to lift your course of measure in order to restart the process of dialogue and continue in a climate of peace and peaceful coexistence. We're ratifying what we urged them to do, correct? And you are saying that the course of measure should be lifted in order to be able to restart the dialogue process. Is that right? That is what I'm urging them to do, because in that same part, the word urge is being used. At no time have I said, if you don't lift the course of measures, then I'm leaving. Because that is not the function of the Ministry of Energy and Mines. If they don't lift the course of measures, then I am leaving. You're referring to the OGGS? That is what I would say. I'm not affirming this. You were mentioning something that is contrary to what I've said. When we say urge, we ask them to lift the course of measure. Here at one point I say, and this is one way to put it, at one point I say, if you don't lift the course of measure, then I'm leaving. That's what I wanted to say. This is what I've wanted to tell the tribunal. Let's not distort what I'm saying. Let's turn to tab 41. And this is a document sent by Mr. Leon to Mr. Ulloa, and we know this because of the email that appears there on page 4.
It's the first page in Spanish. And this email was sent on 20 February 2019. There is an attachment here, which is a memorandum that details the actions taken. And here, mention is made of this letter on page 2 of this memo. And it says, with the official letter 004-2019, this is the parent letter, the Assembly agreed to continue with the dialogue. Do you see that? You're talking about the official letter, number 04 from Param? Yes. Did you see the? Did you read that phrase? And then it says, likewise, by official letter 28/2019, dated February 18, 2019, the OGGS responded to the community of Paran regarding their request, conditioning the continuity of the dialogue to the previous lifting of the measure, the protest. Conditioning, it says. I don't think we're looking at the same document. You were talking about a letter by Paran? No. This is a memorandum, sir. In the exhibit you have shown me, I don't see any memos, Counselor. This is the document, sir. Mr. President, it needs to be made clear that that document is not a memorandum. It is an aide-memoire. As I said in my statement, initially, an aide-memoire is a snapshot of the moment in time. That's an aide-memoire. It's not a memorandum.
We shouldn't get too involved in the nomenclature of how pieces of paper are described. In any event, you have before you the document that is being referred to, and in your view it's an aide-memoire, not a memorandum. That's fine, but you have the document. Do you have the document? Sorry, the transcript doesn't read nods of heads.
Yes, Mr. President. I was looking physically at a memorandum. The format of the document is different, sir. It's different from an aide-memoire. It's just an observation.
You've explained yourself, but you have the paper in front of you, do you?
Sí, señor presidente.
I do, Mr. President, yes. Do you see the paragraph that says, with official letter 004? Have you read that paragraph? And you have it on the screen as well, if you wanted to look at it. Correct. As you can see here, Mr. Leon is saying that the letter stated that there was a condition placed upon the continuity of the dialogue to the previous lifting of the protest. Do you agree? It says conditioning here. This document, this letter, 018, we've looked at it before. You have asked questions about this. As I indicated in my prior answers a number of times, the request by the Social Management Office was a manner to urge the Paran community to lift the coercive measure as an act of good faith for the dialogue to continue. But it was not an imperative condition. It wasn't a condition per se for continuing the dialogue. Tengo una pregunta.
Can you remind us of who sent this aide-memoire to Ulloa Arteaga Cesar? Who is the author of this? It was mentioned before, but I don't remember, and it doesn't appear here.
Sí.
Yes, the drafter of this aide-memoire is Mr. Nito Leon. Oh, okay, Nito Leon. I wasn't CC'd on it, sir. I don't have a copy of this. This was sent to his immediate superior, which was Mr. Cesar Ulloa. Would it be appropriate to say that that document reflects the interpretation of Mr. Nilton Leon as to the letter, this official letter 0028-2019? No. it doesn't reflect what Mr. Leon says. It reflects the spirit of the letter that we had sent on 18 February 2019. This document was drafted by Mr. Leon, right? Yes. Okay, let's shorten this discussion. We don't have a lot of time. The tribunal is perfectly capable to read and interpret and understand what this says. Thank you. Thank you, sir. One last question in connection with this. I understand that in your letter of 18 February, you did not make reference to Paran's proposal that the meeting was to be held on 19 February, correct? Well, let's see. They suggested the 19th. We looked for the best conditions, right, for both parties to agree on the date. We talked to the opposing party. We also found a slot in the agenda that would be more viable, and the suggestion made to both parties was 26 February, and the meeting was held on the 26th. But in that letter, no mention is made that they have to agree on the date. No reference is made at all as to the proposal by Paran for a meeting to be held on the 19th. Yes or no? As I indicated, these are requests and proposals put forward by the parties. That's an impartial third parties calling the meetings, the MINEM. And they, at the MINEM, asked the parties whether it could be the 26th or 24th, the 25th. Out of the conversations held with both parties, a consensus is reached, and it was decided that the meeting be held on the 26th. The only thing I wanted to clarify is that that came later. In your letter, that proposal was not to be found. In point of fact, there was no proposal in connection with a future meeting. That is done through on-site meetings, on-site visits to the community, and phone calls. Okay, let's go back to your letter. There's another issue that you're dealing with in this letter. Again, it's at tab 20. Could you please show it in Spanish? We're up to tab 20, like I said. This is C191. And we were looking at the second paragraph here. It says first, second, third. Do you see that? Yes. It says, the time that has elapsed with the road blockade in place, more than 100 days, will compel the relevant entities in charge to perform their duties within their powers and in accordance with public policy and social peace. I hereby put you on notice for the relevant purposes. Do you see that? Yes. So, they're saying that more than 100 days have elapsed, that's not a short period of time, and that this will compel the law enforcement forces to act. So here it says, will compel. That doesn't mean that it's an option that they have. I agree with you on that point, but I disagree with you when you're just saying that this is a police intervention, where it says here, other entities will act within their powers. They're talking about other government entities or agencies, entities or agencies of the national government. Peru has 18 ministries. Out of the 18 ministries, 15 to 16 have dialogue offices or dialogue management offices. So when we're talking about other entities are going to strengthen the dialogue because the ministry is seeking to strengthen dialogue, and we want the other agencies to also become active. For example, the Ministry of the Interior, the PCM, the Secretary of Social Management and Dialogue, the Ministry of Transportation, the Ombudsperson's Office, other offices that may guarantee social peace. In your second statement, you said that on 13 February 2019, a few days before this letter, you spoke to Mr. Bravo in connection with the police intervention. Where in my statement do I say that? Paragraph 28 of your second statement. Mr. President, this is the interpreter. Can counsel speak closer to the mic, please?
Counsel, we've had a request from the interpreter that you lean into the mic a little bit.
Thank you, sir.
Why don't you say something? Let's see if it's satisfactory.
This is good, Mr. President. Thank you. Yes. And here, paragraph 28 of your second statement, you said, consistent with the foregoing at the meeting on 13 February 2019, I encouraged Invicta to continue the dialogue regardless of whether the company was still attempting at the same time to make the PNP to lift the blockade with the use of law enforcement. This was a few days before your letter. In your letter, you were making reference to an involvement by the police. Let's see. Paragraph 26, I also, of that same document, at 26, when Mr. Bravo says that I agreed with the police intervention, I clarify that that was not true. As the Office of Social Management of the MINEM, and I've said this before, we do not use to solve conflicts the use of law enforcement. Because that is not a tool that will allow us to bring about dialogue and agreements, right? That weakens dialogue. But you knew the plans that the police had at the time to become involved in the matter. No, I did not know of the plans of the police. The police has its authorities that determines the plans, the involvement plans that are going to be used. As the ministry, we do not have any jurisdiction over the national police. Let us go back to the aide-memoire that we had looked a moment ago at behind tab 41. And again, this is C468, dated 20 February 2019. If we look at the page that says actions taken, he says, and that action to be implemented on page 2, the PNP has prepared an operational plan to effect the unblocking of the access roads and the approval of which is pending by the Ministry of the Interior senior officials. So Mr. Leon at least knew that this operational plan was undergoing. There was a weekly meeting. Didn't he tell you about this? What Mr. Leon talks about here, he's talking about actions to be implemented. It's forward-looking. It's not saying that the police is taking these actions. These are actions to be implemented. So they have prepared an operational plan to effect the unblocking of the access roads, the approval of which is pending by the senior officials. They can prepare this, but an operational plan is not a matter of public knowledge, right? An operational plan, well, that's the jurisdiction of the national police only. Okay, according to you, that's only the jurisdiction of the national police. But here we have an internal document from the OGGS. It appears that this information is being shared. The police, at least, has informed Mr. Leon that an operational plan exists and that that plan will be implemented in order to lift the blockade. In the national government or in the Peruvian state, information is passed on from one agency to the other via an official letter, right? Is there an official letter informing us of these operations with the police? No. So any comment may be made, any data could exist, but no official information came to us from the police indicating to us that the police was preparing an operational plan. At the beginning of your testimony, I think we clarified the manner of communication with your superiors and with your subordinates. And you said, I think, that aide-memoirs were sent to your superiors. But internally, amongst yourselves, within the OGGS, meetings were held, weekly meetings, using PPT presentations. I understand that the purpose of this document was for it to be sent from the OGGS to your superiors within the Ministry of Mines, right? Yes. But there's a filter here that this goes through. When I say that we had no official information, right? If things are not official, I cannot pass them on. I can have information from an expert under me, but for me to be able to pass on that information to my superiors, that has to be done via an official channel. I cannot use mere suspicions. We did not receive any document from the National Police saying that they were preparing an operational plan. Sir, you are a fact witness here. You're not here as a witness of official communications. As a matter of fact, did you or did you not know of this? What you have been asked is whether you knew of the existence of a police plan subject to the approval of senior officials. Did you know of this, officially or not officially? No, sir. Okay, thank you. This aide-memoire, did you receive it? No, I was not CC'd on the email. Cesar Ulloa was the only person CC'd on this, the coordinator. Do you know why this aide-memoire was prepared? What was the purpose of it? Yes, it was to hold a meeting with Invicta representatives. My understanding then is that what is being done here is provide information to your superiors so that they are well informed when a meeting is held with Invicta, right? This was information that was being provided to Mr. Leon and Mr. Cesar Ulloa for the holding of the meeting with Invicta. It was a preparatory meeting because the official meeting was to be held on 26 February, and we're talking about 20 February here. There's something I don't understand here. At the beginning of our discussion, you said to me that within the OGGS, you didn't really have written communications. You held PowerPoint presentation-related meetings. And then when you held meetings with the Ministry of Mines, you prepared reports or aide-memoirs like this for the information to be transferred on. So I'm not really understanding. Now you're saying that this aide-memoir ended with Mr. Ulloa. He was a direct superior, and I'm sure that you saw them every day. Let me answer a question. The aide-memoir go through filters. It's not that the expert prepares an aide-memoir and it goes to the senior officials. No, it goes through filters. The coordinator, Mr. Ulloa, then we go to Mr. Ulloa's boss, and then to his boss's superior. So this only went up to Mr. Ulloa. It didn't go through any other filters. That's why I was saying that only certain pieces of communication or analysis are passed on. What you're saying is that this aide-memoir perhaps would have gone to the senior officials, so it was first sent to Mr. Ulloa for Mr. Ulloa to review it, but that's where it ended. The buck stopped there. It stopped with Mr. Ulloa. That's what you're saying? Yes, because otherwise it would have followed the regular procedure. Mr. President, members of the tribunal, aide-memoirs, as I said, are temporary in nature because social dynamics change and social conditions may change overnight. So if we want to have an aide-memoir as an instrument that allows us to get the knowledge of the situation in connection with a certain moment in a certain time, then that cannot be used in other instances. They have to be reviewed, they have to be updated, and they have to be processed. The aide-memoirs, that is. ¿Cómo estamos?
Do we need a break, or should I continue?
We are scheduled for a break in 15 minutes. I think we're okay to proceed on that basis, so why don't we take 15 minutes?
Or, yeah, we wait, 15 more minutes.
Well, you're right, we'll have the lunch at the regular time. Yeah, we'll have the break at the scheduled time, which is 15 minutes from now.
Bien.
Very well. Let us go back to your letter. Behind tab 20. This is C191. And we're going to look at the third paragraph. And it says here, what is stated above in the preceding paragraph is closely related to our duties as advisor of the High Directorate on Social Matters and is relevant to all front-line departments. Do you see that? Yes. It appears that what was indicated in the preceding paragraph was agreed with these senior officials. Well, the Office of Social Management is an advisory body to the higher management, to the senior officials. That's what I'm saying. That is the structural link that exists in connection with this office. So it says here that there is an advisory relationship with the senior management. So why are you saying that? There are many jurisdictions, and this is the one that is highlighted here. No, let's see. Our jurisdiction, we are an advisory body to the minister only. We report to the ministry, not to the vice minister, no, or the secretary of the ministry, no, the minister. As advisors to the minister, you were saying that the preceding paragraph, the one that we saw before, well, you're saying that, right? Are you talking about the whole paragraph? We're talking about the whole paragraph, not the first, second, or third item here, right? Well, let's go to 43 again. This is C570.
Document, let me clarify something. There was some ambiguity in the testimony about whether this was written by Mr. Leon or whether it went to him. My understanding was that he was the author of this document?
Yes.
Thank you.
Así es, señor presidente.
That's right, Mr. President, that's right. I was the one that wrote this document.
I think you're referring to C468, and yes, Mr. Leon was the author, and that was clarified by the respondent in the document production process.
Right, understood. I think, sir, Mr. Trigoso, there's some confusion here, but we were talking about a different document. So now we're going to discuss the, well, I'll give it back to counsel.
Thank you, Mr. President. Tiene delante el documento.
So you have seen this document at tab 43. It is an email sent by Mr. Leon to the chief of police in Sayan on the same day that you issued the letter that we saw before and that you signed.
Y
And you are copied in this email. And did Major Soria know that you were the person who drafted the operations plan? Let me clarify the question. Here you're writing to Major Soria. Did you know that Mr. Soria had drafted the operations plan by now? I do not know. However, Mr. President, if you allow me, in connection with this document, this email that was sent to Mr. Soria from the Sayan district, the only goal was to send to the president of the community the letter mentioned. Why? Because the ministry, to get to Sayan and provide the letter, would have to take 12 hours. But because of logistics, he communicated via phone so that this letter be delivered, and we know that the president has received the invitation letter to a dialogue process. That is the purpose. The purpose is not to get to know operational plans, etc. This is just for the police or the police station to help us deliver this. This was the goal of this email sent to Sayan. However, this must have been read by the police officer, correct? Certainly. And he would have known of what the OGGS is saying. I cannot assert whether this has been read or not. We sent the email for him to send to the president of the community this. This was the goal of this letter. We saw before that you had the obligation to coordinate, yes, to coordinate with the public forces. Isn't it right? Coordination is not done by Trigoso, that I am at the third level for the decision making. I can make a decision with the general or the minister. I may do it with the commissioner, but it was not within my power to do so when it was a higher type of decision. There had to be coordination. I was given an office of coordination, but I could talk to I didn't have the jurisdiction. I didn't have the competence to ask those questions or make those decisions. At the beginning, and I am not going to show you this, I am just going to read, and if you want, after I read it, we can go there, but the Supreme Decree that refers to the role of your office, the office that you directed. And here it says, to draft and carry out crisis plans and also to coordinate with internal forces. You were the director of the office, and you had here as the main role to give to the coordination, direct coordination with enforcement, law enforcement. And there it says, comma, whenever applicable. So whenever applicable, that's when I had to do it, or when the high management had to do it. But this was not within my purview. And if the sole purpose was for that letter to be conveyed, why didn't you send, for example, a letter to the mayor or the sub-prefect or any other authority that is equally close to Paran? Because mainly the documents in Peru, for them to be official, for them to be valid, have to be issued by have to be notified by the police forces. There is an administrative process. I am not a lawyer. I cannot explain it. And whoever will explain the legal aspect may do so, but it is the police, the one that serves notice of any of these notices for them to be valid. And that's the reason why notices usually have the support of the national police forces, and we usually get it from them. I I can ask the mayor to send a letter. I'm certain that the mayor will not send it because the role of the mayor is different, and that is not the role to serve notice, whereas this is something that is usually done by the police forces. We're going to look again at this document that we were looking at. This is tab 41. We are in between both documents, C468. And once again, you were saying, and once again, this is 2 days after your letter, that the National Peruvian Police has established an operations plan pending approval by the High Management of the Interior Ministry, or Ministry of the Interior. Would you please tell me who is part of the leadership of the Minister of the Interior in terms of the positions? I'm not looking for names, just positions. Let me offer you 2 answers, if you allow me, Mr. President. To answer your question about the management, ministers, vice ministers, and the General Secretariat, but the operational plans are not approved by the Ministry of the Interior. That is separate. The approval and the implementation is separate. And this is what I was able to see. I would have to review that from the legal standpoint, and that is something that has to be in the hands of the National Police. They are the ones who plan and implement. And there is a reason behind it, but that's the issue. The Ministry of the Interior does not develop police operational plans. Witness. You are not an official with the Ministry of the Interior, correct, and you're not a police officer, correct, and you're not a lawyer, correct. Thank you. At any rate, this was the understanding of Mr. Leon, and this was this communicated in the weekly meetings, that this was your opinion? I already addressed this topic, and I ratify what I said at the beginning in connection with this. Yes or no? Let me repeat. This document was addressed to Mr. Cesar Ulloa, and it could be the opinion of a specialist. And as the member of the tribunal just said, Mr. Leon is not a member of the Ministry of the Interior or the National Police. So the opinions may just be opinions, but the knowledge is not official.
Mr. President, I'll just carry on going until you tell me to stop.
I think this would be a good time to stop, and the record will show that that last sequence of questions was actually Ambassador, I've promoted him, Arbitrator Garibaldi, and not me. I have not done anything of that wit and brilliance in a long time. So, all right, let's take a 10-minute break.
Gracias.
Okay, are we ready to proceed? Okay, interpreters okay, everybody's okay. All right. Well, welcome back, and let us then resume the questioning.
Thank you, Mr. President. Señor,
Mr. Trigaso, we were looking at the document at tab 41. And if we scroll down, let's see if I can find it. Just before recommendations, it says likewise. We know that also it is known that the local police forces of Peru are preparing an operations plan in the community, having identified long-range weapons among the community members. Do you see that? Yes. Were you aware of this operations plan, whether it was official or unofficial? It was probably a different operations plan, different from the one to put an end to the blockade. I was not aware of that. So Mr. Leon did not tell you this during the weekly meetings about your knowledge of this operations plan? As I mentioned before, and as I said by the member of the tribunal, neither I nor Mr. Milton are specialists in the subject. We do not even belong to the Ministry of the Interior or to the National Police Forces. Just above this paragraph that we just saw,
Señor Testigo,
witness, you cited a member of the tribunal and you referred to me. I was referring to your opinions. A different issue, a different matter, are opinions about which a witness needs to have a foundation because of the knowledge of the law or his or her position. Different from this is the factual knowledge of the witness. So please do not cite me. I apologize, and let me continue then.
y aquí,
And here, as stated by the arbitrator, we're not talking about official documents. We're just talking about your personal knowledge as head, as manager of the department in connection with the social conflict that is the subject matter of this arbitration. And in this said memoir, at the paragraph that we were looking at, just above, there is another paragraph that says the social process the mining company has with Paran is affected or impaired by the presence of other stakeholders different from the state, marijuana crop producers. The state is aware of this and is activating the corresponding mechanisms. In your opinion, what would be those mechanisms to be activated by Mininter? I am not aware of these mechanisms, more so the problem between Invicta and the Paran community. We never heard these issues as part of the dialogue process.
Nonetheless, Mr. Leon was aware of this, but it wasn't part of the issues discussed in the dialogue. There's clarity about the agenda, the agreements. At no point on the agenda was there talk of marijuana plantations. Or other topics that are mentioned there. For example, it says the title of lands, nor well, that was the subject of the establishment of the dialogue. Land titling was not mentioned. It was not one of the issues at play. But going back to this topic of marijuana, what would have the Ministry of Interior have done to resolve this marijuana problem? There would have been an operational plan, some police intervention, because this is not going to be resolved through dialogue. Look, the marijuana plantation, as I understand it, is a crime. The Ministry of Energy and Mines doesn't look into criminal activity through a dialogue, because the Office of Dialogue is not a court. It does not establish regular justice. It is an office for promoting dialogue, and it deals with cases that's between the parties through mechanisms in its management process. Understood. But it seems that these are observations that are specified there. They're observations in the two paragraphs I just read, and this led to the consequent recommendation, which we're going to read now. If we could go down to the paragraph on recommendations. First, coordination at the highest intersectoral level between the MEM and the Mininter in order to activate as soon as possible the mechanisms for the reestablishment of public order in the area by Mininter. And then it continues. Dialogue mechanisms are not appropriate in this case because community leadership manages a double discourse with the state and with its population, evidencing thereby the presence and active participation of local actors who, with an economy that is outside the law, subsidize activities contrary to the public order against the mining project. So would it appear, based on what I'm reading here, that there is an account of the issue? Mr. Leon, who is the person who is on the ground, is saying that this population is heavily armed. That's going to be resolved through an operational plan. This population has marijuana plantations, which is obstructing the dialogue. There will also be an operations plan in that respect. And finally, there is a blockade, and there will also be an operational plan in that regard. And the dialogue is not appropriate. Were you familiar with this opinion of Mr. Leon? Yes. Look, it's a recommendation within the administration. Recommendations are not binding. They're a matter of analysis for decision-making. Now, Mr. Leon is a social specialist. He can say that there are marijuana plantations. No doubt that's based on information he's been given, but he hasn't verified it on site because that's not his function. And I reiterate, the function of the Ministry of Energy and Mines is not to take up these issues that you're mentioning. These issues are crimes. We at the Ministry of Energy and Mines are not competent to look at these cases. We look at what's the issue. The population says that there's a negative impact on its community. The company says they have put up a blockade to the mine. That's the issue, and it's on that basis that we've outlined a whole strategy for dialogue so that the parties can find consensus. That's what the ministry does. If there were collateral actions, well, they wouldn't affect the dialogue process. Mr. Trigoso, I understand what you just said, but there are other factors that are being noted here by Mr. Leon. He's saying that here there are long-range weapons, and there is marijuana, crimes in effect, and that therefore it is not appropriate to go forward with the dialogue. Did he communicate this to you or not? That was my previous question, and you didn't answer it. No, he did not communicate these issues to me, and because they were not part of the issues that we were dealing with. And when he says that it's not appropriate to go forward with a dialogue, well, we would not be engaging in dialogue with criminals if there had been this presence of drug traffickers and, say, criminals with long-range weapons. We, as the General Office for Social Management, we can never establish a dialogue with these people who are acting outside the law because we would be recognizing their activity. And what you just said makes a lot of sense. It makes a lot of sense, and that is why Mr. Leon is saying that dialogue is not appropriate. It's his opinion. I'm not saying that you need to ratify it, but I am reading properly, correct? Yes, that's right. It's logical that how is a government office going to engage with people engaged in illegal conduct? In Peru, nor anywhere else would they be engaging in dialogue with persons who are acting outside the law. There are other mechanisms of intervention, but not an office that is in charge of facilitating dialogues to find consensus-based solutions to a social problem. So you're telling me that had it been proven that they had short or long-range weapons and that they had marijuana plantations, then it would not be appropriate to go forward in the dialogue, right? There would not have been a dialogue. The institutions need to step in, the institutions that are in charge of eradicating such situations. Correct. But as for the OGGS, that would have ended any possibility of dialogue until the other institutions stepped in. Well, you're talking to me about a hypothetical. If there were, you're asking me in the conditional and then putting these situations to me. No. So we in practice say, is there a dialogue? Yes. Is there a social agenda? Yes. Is the social agenda being addressed in this space for dialogue? Yes. So that is the issue. At no time has there been any discussion of drug traffickers or persons with long-range weapons. That's not part of the dialogue process and agenda. Actually, Mr. Trigoso, we don't have all day. Mr. Leon is telling you, or telling Mr. Ulloa, internally that these weapons exist. That's a reality, and the community of Paran has marijuana, that they are drug traffickers. That is what he is saying. In other words, they're criminals, and therefore it is not appropriate to go forward with the dialogue. And I believe you're telling me that in that case, we as OGGS could not continue. Other institutions of the state would have to step in. Are we in agreement on that point? We are in agreement in the hypothetical that you're putting to me. Now, to generalize and say that a community is all drug traffickers, or to say that the community, generally speaking, is armed, well, I don't think that I could risk making such a characterization. Very well. Let us then move on to the letter that came in 21 February from Paran. You discuss it in your first statement at paragraph 37, and you say that on 21 February we received a satisfactory response from the community of Paran to the letter that we were looking at earlier that you drafted dated 18 February 2019. That's right. Let us look at that letter that you got from Paran. It is at tab 24. It is Exhibit C 198. And in the second paragraph, this letter, well, it's directed to Mr. Francisco Ismodes, who I believe was the minister, right? Was he the minister? Yes, Minister Francisco Ismodes. I'm sorry, I'm just trying to find the letter. So sorry, it's at tab 24. Do you have it? Yes. And in the second paragraph, it makes express reference to your letter, and it says that you asked for, demanded equality of conditions. You see it? Yes. And it then says, well, excuse me, before we get there, in your letter of 18 February, when you made reference to equality of conditions, you were saying that the negotiation had to be carried out without any measures of force. Yes, this is what I reiterated in this letter. And Paran says the following in the letter. Minister, we ask that you guarantee suspension of the forceful measures, and from Invicta Mining Corp, a suspension of the criminal complaints to enact the aforementioned conditions. In turn, I ask for your intervention to be able to continue the dialogue roundtable through which we shall reach an agreement according to official letter 0028. This agreement will be on 26 February. Now, we're not going to give the Cervantes Award for this drafting either, but it seems to me that what Paran is saying here is that they're negotiating with you. They're telling you that we will lift the coercive measure, forceful measure, only if the complaints are withdrawn. That's what I understand, that they're telling you. Am I right? They don't negotiate with the ministry, but rather they put the conditions to the company, Invicta, because we don't have any competence to withdraw complaints and what they're asking for. Very well, but you had said in the earlier letter, lift the coercive measure and we'll continue to pursue the dialogue. Answer, we are not going to do so unless the complaints are withdrawn. That's what they're saying, right? And that was then conveyed to the company. And the complaints that had been lodged, were they improperly put from your point of view? The complaint they're referring to is for the takeover of the mining unit. That's what I understand. And then a prosecutorial file was opened. I'm not familiar with that prosecutorial process. That's what they're referring to. Complaint had been lodged for coercion and extortion, and after they lifted the blockade after the 21 November meeting. Also, a complaint was lodged over violence against the authorities, threats to the authorities, illegal possession of arms, robbery, and this was after the failed attempt of the Office of the Prosecutor to inspect where the gunpowder was. They didn't, or rather where the explosives were. So do you believe that these complaints were not properly lodged? Well, as I say, these complaints are lodged in the realm of the judiciary, of the prosecutorial authorities, and that has its process. So I would, well, in other words, so long as the criminal complaint is maintained, there's no dialogue. The criminal or the prosecutorial process being an investigative one, and they are the ones who determine the innocence or guilt. Until such time as there is a judicial decision, we cannot treat anyone as a criminal or characterize them in any such manner. You then met with Mr. Bravo on 22 February, right after this letter, and you discussed with him the position of Paran. After this meeting, Mr. Bravo sent you an email on 25 February attaching a draft document of abandonment that would be presented if Parang were to lift the blockade. Do you not recall this? I've seen a document that I've reviewed. It is a proposal to abandon the complaint, but it is not that. It's a proposal. I don't know if you could tell me where. Of course, that's at tab 25. It's Exhibit C 199. And it's an email that was sent by Mr. Bravo with a copy directly to you. And he says, as discussed, please find attached the following documents for tomorrow's meeting with the Parang community. And there is the form of withdrawal of criminal complaints, and then a draft protocol of agreement setting up the formal dialogue process, well, what was discussed with the process with Invicta. You received this email. And despite the seriousness of the crimes committed by Paran, Invicta was ready to yield with the aim of the blockade being lifted. Is that not so? This was the positive disposition on the part of Invicta to renew the dialogue. Now, here, we cannot affirm or deny the facts being investigated, because no one knows, that is to say, it's only up to the prosecutorial authorities to pursue the investigation. But you do confirm the goodwill on the part of the company to engage in dialogue? Yes, I confirm the predisposition of the company to engage in dialogue, and the community as well. One needn't speak only of one of the parties, because there are two parties that come to agreement to engage in dialogue, and you have the letter from the president of the community saying, I want to engage in dialogue with the company if the following conditions are met. And then the company puts forward the conditions on the basis of which it wants to engage in dialogue. So it's the parties who need to come to agreement and see what the conditions are for being able to pursue the dialogue. So let us now turn to the meeting of 26 February 2019. And I understand that you were present, at least for part of the meeting. Can you confirm that? Yes, I, as director, in order to convey confidence and good faith on this process, I did go and there for the opening of this dialogue roundtable on the 26th. And there the OGGS said that Invicta was willing to withdraw the complaints, but that Paran had to lift all coercive measures so as to be able to proceed to install the dialogue roundtable. That's what the OGGS said, correct? Can you tell me where you are at in the file? First, let me ask if you remember that, and then let's turn to the document. I don't remember the details, as I was saying. I was only for the protocol process, and then the specialist stayed. This proposal made by the company to the community was put to the community. The community then asked for a break to have an internal discussion, and I don't know this because I was there, but rather because the specialist told me about it. They wanted to have first a break so as for the community to be able to make a decision. Let's turn to the document. It's at tab 36. It's a WhatsApp communication sent to Mr. Bravo on that same day, apparently. And at 1:13 and 14 seconds, you sent him the following communication. A recess has been taken so that the internal debate on the proposal made by the OGGS on the lifting of all measures of force and of the criminal complaints against the leaders and the installation of the dialogue table, for which the MEM OGGS will guarantee the fulfillment of the commitments that are assumed at this dialogue table. So going back to what had been proposed to you, which is that the OGGS would be the one to propose that all measures of force would have to be lifted, and, on the other hand, that Invicta was willing to withdraw the complaints. That's what was proposed, and it seemed reasonable to the OGGS to put it, to transmit it. Correct. And then, as regards the measure of force, this was addressed in the agreement. Let's look at it. This is in C200, which is at 26, tab 26, excuse me, of the binder in front of you. And at item 5 on the last page, there's talk of suspending all coercive measures. Right? Correct. And I understand that there was only one, the one that was on the access road through Laxanga. Well, the coercive measure was by the community of Paran. Correct. They built a part of the access road to the mining unit, which one could also enter through Laxanga. And if we see in the agreement that you mentioned, you can look at item 4 of the same agreement, and at no point in number 5 is mention made of Laxanga. In other words, according to you, there was no coercive measure in the community of Laxanga? Yes, there was, but the objective of this agreement, which the company also sought, was to enter the mining unit. The company went in to the mining unit through Paran, and I'm not the one who says it, they themselves say it. In their letter that was sent to me on 20 March, at number 2, they say that they entered after the March 2nd assembly with the community. They went into the mining unit on March 4th. There's talk of suspending all coercive measures, right? Yes. And according to you, there was only one measure in Paran. I disagree with that, but let's continue. But there was also a coercive measure along the road through Laxanga. Yes, and the coercive measure on the road to Laxanga was not lifted. And here it says all coercive measures. So I don't understand very well what you're saying, because if we're referring to all coercive measures, it would include both, right? The thing is that in the discussion and the agreements that they reached, it's not a question of the Ministry of Energy and Mines intervening in the proposals and counter-proposals made by the two parties. The two parties agreed upon what is written. Nor can we interpret the agreement. It's the parties who need to interpret it, because the spirit of the agreement came out from the discussion that they themselves had, and they say, guarantee the activities, the development of the activities of the mining company through the access road of the Paran community. This is right there in agreement number 5, last 2 lines. The rural community of Paran guarantees the development of the activities of the mining company through the access road of the Paran community. And you, from the OGGS, sought to mediate so that all the communities would be content. Is that not right? You didn't want to reach an agreement with one community that would have then become a problem with another community. Is that not right? Correct. One must also see, sir, if you allow me to, that the agreements are a construct. So it's not that I construct the agreement. The agreement is constructed through a process. This was the beginning of that process. Now, what's the company's objective? To go into the mining units. And we ask ourselves, did they go into the mining units? Yes. They were not satisfied with the agreement or with the interpretation of the agreement. Well, that could be taken up anew in the dialogue process. One of the parties could say, my agreement is not completely addressed. That's the mechanism. Otherwise, they would just walk away from the process. I understand that, but what's being done here is to lay the bases. Yes, one lays the bases for a negotiation process in the agreements, which, over time, should be reached. Witness, let us set aside for a moment the content of the agreement. The purpose of the activity of your office was to provide for dialogue and for the dialogue to result in agreement between the parties, correct? Correct. That agreement between the parties is a binding agreement, correct? More than binding, it's an agreement in good faith. It's an agreement in good faith. What does that mean? That the obligations, are they legal obligations as long as the agreement stands? No, because we don't have competence. No, this doesn't have to do with your competence, areas of competence. The question has to do with the agreement, the nature of the agreement. Do you understand that it is a binding legal agreement or not? No, it is not. It's not legal. The dialogues are established as an act of good faith, and compliance is there, and the good faith that we or that each party should impose on it. If I, in good faith, enter into an agreement, then I'm going to carry it out. And if I consider that that agreement is not meeting my expectations as a party to the negotiation, then I put to the facilitator once again that the dialogue be resumed so as to improve upon the agreement. Let us suppose that one party acts in bad faith and doesn't carry out the agreement. What would happen then? Is there some solution for that or not?
So the party that's not performing under the agreement is being called upon and asked why the party cannot perform under the agreement. And then the party is going to let us know why it cannot, or why it does not want to perform under the agreement. And so we go back to the dialogue to improve the agreement with the other interesting party and to be able to make the agreement viable. Okay, to improve the agreement. So it is an agreement then. Yes. We, as the Ministry of Energy and Mines, don't have coercive powers. I'm talking about something different. I'm talking about the nature of the agreement. If the agreement is not binding, if the agreement is a good faith agreement, that's what you're telling me, right? But if you allow me, sir, those voluntary agreements, that's what they're called, voluntary agreement, as a mining company to improve my relations with the company I enter into those agreements, those are also included in the regulations. Supreme Decree, the Supreme Decree that establishes that, and you have to have a margin, room to move, if you will, for the company to deal with the communities and improve their relations. In the past, the company said, I cannot enter into voluntary agreements because that is not allowed by the regulations. So how is it that I can go to the company and render accounts before it if the company doesn't allow me to do so? So the ministry understood that these created problems for many companies, and it issued this regulation so the companies can enter into agreements, voluntary agreements with the communities in their areas and improve social relations. A voluntary agreement doesn't mean that it is voluntary for a party to become a party to that agreement, or does it mean that it is voluntary for a party to the agreement to perform under it or not? It is voluntary to enter into the agreement. Okay, so once the agreement is entered into, do you have to perform under it? Well, voluntary agreements are made by the company, and because of the company's reputation, the company wants to abide by the agreement. Is it obligatory or not? Is it mandatory or not? It is not mandatory because these agreements are not overseen, but they are followed up by the authorities, in this case, the ministry. Thank you. Mr. Trigoso, what I was getting at is that in this case, Invicta had made an agreement with Laxanga, correct? Yes. Under the agreement, and I don't know if you knew this, but Invicta was contributing yearly 80,000 soles for the use of the Laxanga road. Did you know that? Well, I didn't know that. Laxanga was not involved in this dialogue. There were only two parties in the dialogue process. There were no third or fourth parties. And then I found out later that they had agreements with Laxanga and Santo Domingo. There were other communities in the area of influence. But like I said before, this was not a problem that came up to set up this dialogue. But the dialogue doesn't happen in a vacuum. There is a problem here with weapons and marijuana. There are agreements with other communities. That's a fact. Those agreements have to be respected. And there's also another fact, which is that the company has invested substantial amounts in the construction of a roadway that it cannot use because the roadway has been blockaded. You are not taking these things into account? The spaces of dialogue don't really set aside the other commitments that a company has with other actors. These are spaces of dialogue, and you work socially in those spaces of dialogue. And as a ministry, we have said, okay, you need to step down from your commitments that you have made. The Ministry of Energy and Mines is not a party of a negotiation process. It is a facilitator. It facilitates the process. The parties are the ones that put forward their arguments, their positions, and their interests. And they are the ones who ultimately make decisions in this connection.
I want to be clear on the testimony here. The transcript essentially says that the ministry's position was that the claimant had to step down from the commitments it had made from the Lasanga community. Is that your testimony? Is it the ministry's position that they had to walk away from their agreements with the other community?
No, that was never said. It was never mentioned during the process of dialogue. The community of Lasanga. The community of Lasanga was not involved in the.
Transcript has you saying that. And is that a misunderstanding of your remarks?
Seguro.
Surely. Again, Mr. President, Lasanga was not a party to this dialogue. They never came in as an affected third party.
I understand they weren't present. I'm just trying to figure out how their interests entered into this discussion, if at all, and apparently the answer is that's not part of the process that you were involved in.
That is right, Mr. President. If the mining company had agreements with Lasanga and with Santo Domingo, those agreements must be respected. At no time at the dialogue table, the ministry has promoted the non-compliance of commitments by the company with the communities around it. On the contrary, as the Office of Social Management, we promote the compliance with commitments assumed by mining companies vis-a-vis surrounding communities, rural communities.
Con lo cual, si tenéis.
So, if your obligation is to promote agreements with the surrounding communities, what was being created here, in accordance with your interpretation of the agreement, is a problem with the other communities that were in the area. Because if the Lasanga roadway could no longer be used, then the Lasanga community was not able to reap the benefits that it had agreed upon with Invicta. Did you consider this? One moment. You're interpreting this agreement from a legal viewpoint. We never said that the commitments should not be complied with. We said that the commitments and the agreements are constructed, they're built. So the purpose, really, of a mining company is to go into the mining unit. So there was a blockade, and they wanted to move ahead with the process of negotiation. It's not that you're going to solve all of the problems of the mining unit in one single meeting. So a dialogue lasts a certain period of time, and it depends on the different mining unit. There are different purposes, problems that the communities may have, but to consider that at one meeting, because there was a set of minutes drawn, all of the problems were solved. Well, that's not the thing. You have a series of meetings, and then you come to the final objective. What we're discussing here is the agreement that was indeed made at the time, right? And there is a difference of opinion in this regard. Let's look at tab 45. But if you allow me, sir, no, let me show you the document. But let me say something, please. I think we're going to lose continuity of this idea. I can, with all due respect, just to go ahead and continue in this connection. If we look at the initial paragraph at point 3, it says there was a list to deal with the issues, to deal with these different matters. And it says that they had to create a schedule of meetings. They're not saying that one meeting is it. Other meetings are going to be held. And we saw that more meetings were going to be held. It's not that the meeting of the 26th was going to end everything and be an end all and everybody was going to be happy. I just wanted to say that with respect. Thank you. I understood that perfectly well. But if an agreement is reached for the dialogue to continue, whatever has been agreed has to be respected. Because if we start on the wrong foot, we're going to continue on the wrong path. Yes or no? Yes. But let's look at the documents. Who started on the wrong foot? You said that the community started on the wrong foot? Well, that's what we're going to look at now. Okay, very well. Look at 45, please. Tab 45.
¿Qué es el anexo?
This is C572. And this is a report sent by Milton Leon to José Luis Carvajal Briceño. He is the Director General of OGGS. You see that? Yes. It appears that this is an official matter, and he's addressing his superior at the time. Do you confirm that? Yes. Yes, my immediate superior, yes. And if we look at the next page, and we look at the conclusions page, and we look at item number 3, again, this document came 2 days after the agreement, right? Mm-hmm. It says that the suspension of the protest was agreed, and also the amendment of the blockade access roads scheduled by the parties for March 2 with a ratification of the Community Assembly in the presence of the OGGS. And this was agreed at the last meeting on 26/2/2019. So your superior is being informed of your interpretation, your office's interpretation of the agreement, and this report is prepared to send it to the Ministry of Foreign Affairs, correct? Yes. So that reflects the position of your office and OGGS. What is your question, sir? Does it reflect the opinions of OGGS? It reflects the opinion in the minutes that were drawn. We, what we do is we give opinions. We do not interpret agreements. The agreements are between the parties. The parties agree on things, and we take on the agreement. And this was an abandonment of blockade of access roads. Here says access roads. It should be, I think, 2. There should be 2 or more roads here. But in practice, yes, there were 2 roads that had been affected. Councilor, what I want to say here is that the purpose of this was for the mining unit to have an access road. They were building up agreements, and in the different items on the agenda, they said that there was a schedule of meetings. This was a first meeting, and we saw that there were agreements that had been made here. There are differences in interpretation between the parties, and then the agreement is improved or it is changed, and this depends on what the parties want, not what the ministry wants. So it's not that 26th of February was a be-all and end-all. Okay, very well.
You've explained that multiple times. I think we understand that. But I have a couple of questions, if I may, about this document at tab 45, C 572. Could we take a look at that again, please? This was the memorandum that was to go to the Ministry of Foreign Affairs. Do you have that, sir? I have a number of fairly short questions.
Sí, señor presidente.
Yes, Mr. President.
First question, why was it necessary to inform the Ministry of Foreign Affairs?
The Ministry of Foreign Affairs, at the request of the mining company, has sent a document to the Ministry of Foreign Relations via its embassy, the Embassy of Canada in Peru. So they asked for information about this case. The Ministry of Energy and Mines submitted that.
Thank you very much. Now, my next question, I'm looking at the conclusions, and I just want to clarify, and perhaps you've already gone over this, but I want to be clear in my own mind, if I may. It was agreed, I'm looking at the third bullet point, and again, we have already discussed this, but I want to be very clear. It was agreed to suspend the protest measure, abandonment of the blockade of access roads. And that presumably includes both roads, does it not? Am I reading this correctly?
Mr. President, the agreement that was entered into was to lift all coercive measures. But what it says here is the access road of Paran.
Or maybe I'm just looking at a bad English translation, but in the English it refers to roads plural. So is the translation incorrect? Is that what you're saying?
That's right, that's correct.
Arbitrator Garibaldi tells me the translation is correct.
Sí, es correcta la traducción.
The translation is correct. Mr. President, like I said, the grammar doesn't really match things. It should say everything in plural in Spanish. Le doy la palabra.
That is not correct. That is not correct. You would not say, you would not say vías de accesos. Vías de acceso.
Correcto.
That's the correct. That's correct Spanish.
Gracias por la corrección.
Thank you for the correction, sir. We understand that.
Just leave it. Was the report to the ministry speaking of roads plural accurate or not?
What we were relaying here was the agreement, Mr. President. We were not issuing a value judgment on the agreement. That was not our role. We copied the agreement and we...
Sir, you've told us that repeatedly, and we understand that. But I'm just trying to sort out your contemporary understanding of what was agreed on the basis of important official information that was given to the Ministry of Foreign Affairs. So was this sloppy staff work or what?
No, Mr. President. This report was submitted to the Ministry of Foreign Affairs on the basis of the documents that we had on file that had been prepared by the specialist, Mr. Leon.
Well, apparently those documents envisioned that there would be the possibility of transit on both roads. Is that correct?
Could you please repeat your question in a more precise manner, Mr. President?
Well, I'm sorry, I thought it was fairly precise. The information you sent to the Ministry of Foreign Affairs, as described in this third bullet point, indicates that as a result of the February 26 agreement, there would be the abandonment of blockade on access roads, plural, which conveys the idea that there would be passage on both roads. Am I understanding this document correctly?
Mr. President, what the document wanted to show was the agreement. The agreement was to free up the road via the Paran access road.
To have to agree to disagree here about what the document says. So thank you, sir.
How are we doing in terms of breaks, etc.? Just how long do you think you would need for a break, sir? It's up to you. Okay, perfect. Thank you. Luego pasemos a otro tema.
Now, the topographer was going to conduct a survey related to the construction of the Paran roadway, right? Let's see. Mr. President, Councillor, I'm going to answer your question. The agreement, and what is the number of the document? I'm just speaking about your own statement. Let me ask you the question again, and if you can answer it, please, so that then we can move forward. In connection with the topographer, in your statement, you say that the topographer was going to conduct a study related to the construction of the roadway through Paran. Where am I saying that in my statement? Well, for example, in your second statements, paragraphs 20 and 21. You said 21? 21 is something else. Excuse me, it's at paragraph 50. Page 21, but paragraph 50. Yes. Where am I saying anything about a road? Well, here you're saying that the understanding of the Peruvian community, which coincides with the OGGS understanding of the agreement, is that Invicta undertook to hire a surveyor to carry out a survey of the land in the Peruvian community on which a suitable access road for the project could be built. Okay, an access road. I am not a civil engineer, Councillor. A surveyor or a topographer is hired to prepare surveys so that infrastructure works can be built. A topographer, an individual or institution may hire to do that for those purposes and not to prepare environmental studies or social studies, etc. In his second statement, Mr. Leon acknowledges that the topographer had to identify the affected areas in the territory of Paran. This in connection with damages caused in the territory. Did you know about this statement by Mr. Leon? Yes. The dialogue is a process. There are some agenda items that changed as time went by. The community changed them. You yourself said that it wanted a compensation of $2 million. Well, 2 million soles. Perhaps other issues came up that the community wanted to include in the discussion, or they wanted them to be included in the discussions of at the dialogue table. But then an agreement was reached and everything was included in the agenda of 26 February. The other things are things that happened in the past. We cannot take them as fait accompli. These were proposals during the process, and those proposals landed at the meeting of 26 February. Okay, we're talking about after 26 February, right? And we're trying to see what it is exactly that was agreed in connection with the topographer. In your statement, you say that the topographer was hired to build a roadway through Paran. And I'm saying that Mr. Leon recognizes that he was hired to identify the affected areas and the harm caused in the territory. But that document was before the agreement.
Gentlemen, you're speaking over each other. We need to slow down a little bit.
Correcto.
Okay, correct. Mr. President, what Council is saying, what he's saying in connection with Mr. Leon, well, that happened before the agreement. As I indicated, everything was a process. We had a first set of agendas, second, third, and we ended up with the February 26th agenda. A discussion ensued and approvals were provided. Okay, let us look at the letter from the Peruvian community to the MINEM Ministry of 21 March to lodge a complaint that Invicta had not met the agreements, had not complied with the agreement of 26 February. This is at tab 39, and it is C357.
357.
Okay, it's C357. I understand that this letter was sent to Mr. Francisco Ismodes, and that you saw it at the time, right?
Y vayamos.
Let us now go to the first page. where it says at number 2 that on the 20th of March, the topographic survey, identification, and location of the affected surface lands of the Para rural community by Invicta Mining Corp. SAC should be initiated according to the chronogram of the agreements reached between the mining company and the Paran rural community. So this reflects the agreement of February 26th, 2019, correct? Yes. And then on the following page, I request an urgent meeting with representatives of the PCM, representative of the Ombudsman's Office, representative of the Agency for Environmental Evaluation and Supervision, ANA, to reach agreements on the non-compliances that are not being met by Minera Invicta. And the rural community of Paran is still affected with environmental contamination within their community lands. For the reason we request urgent meeting. Again here, this letter does not refer to the fact that the non-compliance is related to study for the construction of a road. Yes, but as you can see, it also states another issue. There is a recognition of what was signed on the 26th, and there is also recognition that there needs to be a field visit on the 20th of March that wasn't conducted. And there is also a request with other actors or with other authorities. The Ombudsman, also the President of the Council of Ministers, so there is an expansion of the invitation and it introduces other issues. That was not part of the agreement on the 26th of February. Well, this is requesting a meeting with UEFA, and I understand that these are environmental authorities and water authorities, and this is in connection with the lands, correct? Yes. Yes, that is correct. But again, I consider that you need to assess the document. It's talking about the schedule of meetings. It is initiating this schedule of meetings. It says here that this schedule was the beginning, not the end of a dialogue process. And before, you told me that the community recognizes the agreement. That is to say that the agreement refers to surface lands that are affected within the community. It doesn't say what type of impact or whether it is environmental, physical, etc. But what I'm trying to say is that the lands were already impacted, either physically, environmentally, etc., as you have mentioned. They were already impacted, correct?
Could take a short break.
I am done, sir.
Excellent. All right. Let us rise for a 5-minute break.
Thank you, Mr. President.
Sorry, let's then go back on the record and resume the session.
Mr. President, council asked me for a read of time before we start, so time left is what I'm going to read as of now, and like yesterday, this will change by the end of the day, but as of now, I have, claimant has 8 hours and 12 minutes left, and respondent has 3 hours and 1 minute left.
Thank you very much. Cambiamos de tema, veamos.
Let us change topic. Let us look at an ed memoir that Mr. Leon sent to Mr. Ulloa on March 8th, 2019. This is at tab 37, exhibit 351, C351, 357 rather. Exhibit C351, and let me reiterate, this dates, the date here is March 8th, and 2019, and we know it because of the preceding email, and since there was a meeting on that day between Invicta on the one hand and Mr. Galvez, Vice Minister of Energy and Mines, you on the other hand, I understand that that ed memoir was prepared to that end. Do you agree? I do not recall the meeting with Mr. Galvez, Vice Minister Galvez. I recall with the Vice Minister Ischaustegui. As to the Vice Minister Galvez, that was on March 8th. You do not recall that meeting? No, I do not recall that meeting, and I did not mention it in my statement. At any rate, it seems that this is a document that has the letterhead of the Ministry of Energy and Mines, and here we are going to go to the proper page. I see another paragraph that says, if deemed appropriate, it's on page 6. To clarify, Mr. Galvez was not Vice Minister when Mr. Francisco Ismodes was there. Mr. Galvez was Vice Minister with when Mr. Inchaustegui was Minister. I don't think that that is the case. At any rate, you do not recall that meeting. I do not recall the meeting with Mr. Galvez. That's what I'd like to state. Let us look at the paragraph that says, it should be, or it is appropriate. I do not find it. I apologize, I cannot find it. Let me see.
Un párrafo que dice resulta conveniente.
Paragraph that says it deems appropriate to have a high-level coordination between the MEM and the Minter for activating mechanisms in the public area by the relevant sector, with the commitment undertaken by the parties to bring the blockade to an end, We're trying to find it. It is towards the end of the page. It is right at the end of that page. The last paragraph, do you see it? No, I don't. So I'll give you some time to read it to yourself.
Are we looking at?
Very sorry, Mr. President, for that. It's the last page in the memorandum.
Okay. All right. Thank you.
Yeah, it's the only bit that.
Have you read it? I understand that Mr. Leon believes that dialogue came to an end, correct? Yes. And he is recommending for the higher-ups to coordinate between the MEM and the Mininter, correct? Yes. And he is asking to do the same so as to remove Paran from the mining area along the lines with the recommendation of February 20th. No, this is not what we read here. It says to activate mechanisms to allow the reestablishment of public order by the corresponding sector since the dialogue has ended, with the commitment assumed by the parties to suspend the measure of force and lift the road blockade by the community of Paran. I don't understand what it is that you disagree with. You are saying Laksana, but here it says they're asking to evict the Paran community due to territory-related issues. Yes, understood, but this is March 8th. I understand that access was allowed through Paran, and then the only remaining aspect is to have a protest through Laksanga. Correct? Well, that is your interpretation, because, as I mentioned before, in my statements, the agreement was not to use Laksanga to have access, and I apologize, Mr. President, I have to reiterate, but it was through Paran. Even though the Laksanga area was blocked, the agreement did not imply that opening of the area, not even to talk about the territorial issues, because we have no jurisdiction to talk about the ownership of lands, so the territorial issue was not part of the conflict. And once again, we can look at the agenda items for February 26th. There is no reference to territory. I honestly do not understand your answer. Could you please answer? There has been an access through Paran. It is no longer blocked. This goes all the way to March 20th, so it is possible to walk or to use a vehicle to go up. That is to say, a motorcycle, but the only blockade is in the Laksana area, and he's saying that this person is saying that they need to reestablish public order. That is to say, here there is a need to bring this measure to an end. That's the only option. Yes or no? Yes, but as I have already mentioned, to use public forces for a dialogue, the dialogue is still ongoing, It could be the opinion of Mr. Milton that the dialogue is still ongoing because, as the parties had already said, this is a schedule of meetings. So if we are going to understand that on the 26th the dialogue came to an end, that is not the case. The dialogue initiated on the 26th because after many contradictions and positions that I would like to have my agenda point only on the 26th, there is a dialogue process that was initiated with agreements, and then there were some differences and problems in the implementation, but that is something different. But from the Office of Social Management, we identified that problem, we talked to the parties, and finally we sat down to improve the agreement and clarify the agreement. Very well. So what I understand you are telling me is that Mr. Leon had a specific opinion, and here the police forces had to go in, and you as the director did not agree with that. And here they needed to continue with the dialogue, correct? Yes, to continue with the dialogue. And you were totally up to date with Leon's opinion, correct? This is the opinion of a specialist. And on top of this, this is not the first time that a similar memo is written. This is the second time we see that. This, correct? They don't seem to understand your idea that dialogue prevails over force, correct? Yes, correct, because we didn't have the mechanism of resorting to force in case of disputes. Let us look at tab 38, C, 353. And this is a report sent by Mr. Leon to you on March 18th, 2019. And now you are being sent a report directly. Why? Why, Ulloa? I don't remember why he sent it to me. I may have requested it, or maybe he thought proper through his coordinator to send me this report. I don't recall. Wasn't it because Mr. Leon was dealing directly with you in connection with this issue? No, but he was always dealing directly with me. This was a team meeting. We sat down, we had a conversation, and the opinion one had does not become the agency's decision. The agency has regulations to be followed. Let us look at the analysis section. Everything that has to do with analysis. I don't know if you can read that section. I do not want to read it aloud. And let me sum up what I see there. Is that okay? Yes. So, Mr. Leon, so then you think that the end to the blockade in Laxanga was not agreed on February 26th, correct? But this request by the company, since it was presented at this point in time, would not be accepted by Perang at any rate, and that the dialogue should not continue. And that since the dialogue should not continue, public order should be restored with the police intervention. This is what is being said, correct? Well, if we look at the previous paragraph, before I answer your question, it says, however, the reestablishment of public order is insufficient for Peru. So this is whether it was the minister or the Office of Social Management. The Office of Social Management has to request Peru the total opening or release of the access roads, in between parentheses, including access through Laxanga, without contemplating, and this is even highlighted by Mr. Guyoa, that this request directly violates the commitments established between the parties with the facilitation of the state. So he is the one that is even acknowledging that the company would like to have a release of access, but the agreement did not include Laxanga because the company's goal was to go into their mining path, and opening or releasing Laxanga was a different step. And that's why there was a schedule of meetings, and there was a schedule that was drafted on the at the meeting of the 26th, and we have agreements that are being implemented step by step. Question, and was that the interpretation by Mr. Leon? That is to say, based on this report and in the following paragraph, we read in this context, in this regard, we see that the request by the company is beyond the dialogue under the facilitation of the sector and with the support of the Minintem. However, in the face of an access road blockade that does not support any dialogue transit routes through Laxanga, it is expedited by function the reestablishment of public order through the corresponding channels. So, for him, it's okay.
Es posible.
Is it possible that the opening up of the road to Laxanga was not included in the agreement, but the company is asking for it? It's not an unreasonable request. The community of Paran won't agree, and therefore what is appropriate is for the police to intervene. That is what he's saying directly. Is that not so? Yes. But that does not mean that the police, at the request not only of the Ministry of, but any Ministry of Peru, is going to intervene. They do their own evaluations, the identification of harm that might be caused, and based on that, they intervene. One mustn't forget that in Peru, protest is a right, particularly if it's in the public way, because a local road was being destroyed. If I'd ask a bit more of cooperation from you, I only asked you about Mr. Leon's opinion. He's the one sending the memo, and here he is saying that the right thing to do, or the appropriate thing to do, is for the police to intervene. Yes or no? Yes. I said yes, but I'm also clarifying, sir. And you told Mr. Leon at that point, no, this is wrong. Here, the intervention of the police is not appropriate. Did you tell him that? The indication that we have is that just as the police may make the decision to intervene, we maintain dialogue as the principle for being able to find a solution to the problems. And there have been cases where we have intervened with the presence of the police, and we've had to sought the dialogue after this action of the police. We cannot renounce dialogue as a means for solving problems. That's why we're the Office of Social Management. In the midst of crises, we've also intervened. So to say that I, because the police are going to intervene, have to renounce my function, well, that's not the case. We have really limited time, so I'm going to ask if you could be briefer. I know you've got to give me context, but I've asked you something very specific. This memo in this memo, Mr. Leon is saying that what has to happen here is that the police need to intervene. Now, you, in turn, told him that that was not so, and that what had to happen was that one had to continue pursuing the dialogue. Yes or no? Yes? Thank you. Let's look at another document. This is an internal memo of 20 March, 2 days after this, and it's at tab 45. It is Exhibit C 572, and you tell us in your second statement that you did not see this document contemporaneously, correct? Can you confirm that? That's right, but later on, reviewing it, I've seen it for this hearing. But did you receive this document or see it at the time or something similar? I don't recall whether I received it. Were you able to verify in the internal documents that you reviewed? And I understand that in your statement you say that you reviewed some other internal documents. Were you able to confirm whether you received this document or something similar at the time? I can't actually confirm whether I received it because the protocol in the ministry, after once you leave the ministry, your emails are closed off, and I didn't have any access to them. Thank you. Just for the transcript, this is C576 and not C572. Let us turn to, well, we know that this document is dated March 20, even though it doesn't have a date, because under current situation, it says today, March 20th, they're at the blockade points once again. Today, March 20th. And it continues impeding the way to the mining unit. The construction work on the road to the mine has been completed, and that means there are approximately 150 community members are once again stationed at the blockade points, completing blocking access to the mining unit. The mining unit has completed its construction and is operating, which implies having personnel within the mining unit which could be at risk. And then it speaks of, well, then after there's a risk, following the community's decision to resume protest actions as a result of the company's non-compliance, the dialogue has broken down and the executive exhausted this channel to the extent that the non-compliance with the commitment has broken the trust and credibility of the actors participating in the process. And any urging in this regard on the part of one of the actors could generate a perception of bias that allows for escalation or would lead to escalation of the protest. Do you see that?
A little bit. That was giving the interpreter a rather hard time.
Really sorry, sir.
Counsel, I may have missed it, but can you establish the author and the date for this document?
Absolutely, sir. Entiendo que este documento.
I understand that this document was drafted by Mr. Leon. Peru has confirmed it for us in the correspondence that we had with them, because we did ask them. So I'm passing on what the lawyers for Peru have told me. And this document is dated March 20th, 2019. And here we get into the questions. So it's clear for Mr. Leon that it's of no use to go forward with the dialogue, correct? According to this document, according to the document, yes. And this document came, well, we've seen a number of documents, and that we're repeating this, and in the last one you told me that you were told that it would not be appropriate and that it was said again 2 days later. Do you agree? Yes. And in your recommendation, or in his recommendation, he says, given this situation, it is recommended that the public order mechanisms be activated by the Min Inter, which has an action plan for this, but not signed. Given that the current policy is one of non-intervention, therefore, it is proposed that dialogue be exhausted, as in this case. However, since the beginning of the conflict and to date, the policy of non-intervention has prevailed, in relation to which a discussion at the highest level among the deputy ministers is proposed to enable the activation of this plan of action in the face of a scenario like the present one. And so it says, or he says, that there is a policy of non-intervention that is prevailing, and that's why there's been no police intervention, right? May I respond? Of course. When it says here, when he says here, he says, given that given the current policy is one of non-intervention, therefore requiring that the dialogue be exhausted. So when we speak of exhaustion, then that means we need to move on to another stage, where other sectors of the national government are involved that help to strengthen the dialogue forum in order to find a solution as between the parties. And that's why after the 20th, when the company did not follow through on the commitment having to do with the surveyor or topographer, and the conflict resumed. That should be clear. So the PCM, the Presidency of the Council of Ministers, through the Secretary of Social Management and Dialogue, the Office of Human Rights Ombudsperson, Mininter, and the Ministry of Energy and Mines, articulated actions so as to once again get the parties to sit down and resume the dialogue that had been broken off because of the company's failure to follow through, and this led to the measures of force of the community to be resumed. And there are documents, there are emails that went between the PCM, the Ministry of Energy and Mines, Office of Ombudsperson, and so on. I'm trying to understand how one reaches the conclusion that you have just conveyed to me, because here Mr. Leon is saying what has to happen here is that a plan of action needs to be activated. That is to say, the police need to step in, after you've said several times no. And at the same time, you are saying no. Here, after this, 20 March, which was the renewed invasion by the community of the camp. Here, what had to happen was coordination with other institutions, but not intervention. with which you are confirming that what followed this memo was a decision at a higher level to not have police intervention despite this recommendation. Is that not so? Excuse me, what I am saying is that with the exhaustion of the dialogue, because the dialogue had broken down, you had mentioned that because the company failed to carry out its commitment, the community set up the blockade once again. So what do? We strengthen the dialogue forum in order to give greater guarantees to the population and the company, and we can sit them down once again to see in which respect the commitment is falling short, or when they are falling short of implementing the commitment. And this way we would convoke other actors to strengthen the dialogue. It would be different to, it's one thing to have somebody from the Ministry of Energy and Mines, and it's something quite different to have 4 or 5 people from 4 or 5 different ministries of the national government. That helps strengthen the forum. And then some of the expectations of the population of the company, well, they could then work in this dialogue forum. That was the objective. And that decision to convene several different agencies to go forward with the dialogue and to have those additional representatives seated at the table, that decision was taken at a high level. No, it was made at the level of the General Bureau for Social Management. It was made by my boss, the person previously immediately above me. I don't understand, because from that moment, representatives of other ministries sat at the table. How could the OGGS make the decision in that regard? Well, let me explain briefly. The Secretariat for Management, Social Management and Dialogue, the PCM, is at the same level as the Office of Social Dialogue. The Office of the Dialogue at the Ministry of Interior is at the same level. So among them, they coordinate actions depending on their authority, and those representatives sit down. Very well, thank you. Now, what I do understand is that Mr. Leon was recommending one thing, and you, as director, decided that you were not going to follow that recommendation. Is that so? The one who made the decision there was the OGGS, my boss and immediate superior, Mr. Briceño, Mr. Carvajal Briceño. And there are some later emails that were sent by the Presidency of the Council of Ministers to Carvajal and other officials from other sectors so as to strengthen this dialogue forum. And given that Mr. Briceño is a counselor to the minister, I understand that he coordinated that with the minister. Certainly. I did not participate in, nor did I have knowledge of such meetings.
No further questions.
Council, let me just ask you what your intentions might be. We've got about 25 minutes before our scheduled rise. We don't know how long your examination will take. We don't have a sense for how long any
I have some good news. I've finished my cross-examination.
You finished. Well, I'm sorry. I didn't mean to sort of steal your thunder. Okay. So, do we have any redirect? I see a nod. Over to you, sir.
Thank you very much, Mr. President. I'll be extremely brief in light of the time. Señor Trigoso.
Mr. Trigoso, a question. You were shown the document C-351, which is this communication from Mr. Leon to Mr. Ulloa. I'm going to ask my colleagues to put it up on the screen. In particular, you were asked to go to the last page and to read the last paragraph and to comment on what it says and to provide the explanations. Now, the translation, I want to show the tribunal, is the translation only of the last paragraph, not of the previous paragraph, and therefore I'm going to ask you, Mr. Trigoso, to read it aloud, but slowly, so that we can get a translation, because we're not able to put up in English what I'm asking you to read for the benefit of the tribunal. So first, I'm going to ask you to read it slowly, and then, as the lawyer for the other party did with respect to the second paragraph, for you to provide for you to explain what you understand this first paragraph to be saying. Thank you. Very well. Going forward, should one accede to the company's request to condition the community as Ministry of Energy and Mines to a lifting its blockade of the roads in the community of Laxanga that are not part of the commitment taken on in the agreement, the perception of the community, the community's perception of the ministry would become negative in the face of an image of collusion with the company. And with this motivation, they would become agitated, and this would escalate the protest, blocking once again the access road that has been opened, which is part of the commitment taken on March 2nd. March 2nd, 2019. And then all that has been done would be for naught. That second part has been translated. So my question is, having read that first paragraph, could you please share with us your understanding of that first paragraph? Yes, this section that is the last section about going forward, set out by Mr. Leon, is real, because at nowhere in the agreement signed on February 26th is there commitment to lift the blockade on the Laxanga Road. And moreover, if the company were to pressure us to say, go and convene the community and tell them that they also need to free up the road, to leave and free up the road to Laxanga, they might understand that we were working in collusion with the company in order to reach an agreement where the community itself, in its own view, would not have been part of such an agreement, and that instead of improving the relationship with an impartial third person, which is the MEM, then they would see us rather as being tied to one of the parties, and the credibility and trust would be lost, and therefore we would lose any legitimacy in fostering the dialogue. And that is why we always, from the General Bureau of Social Management, have maintained our impartiality, and we have not become involved in the problems that are as between the parties and up to the parties to solve them.
Redirect.
I think the members of the tribunal may have a question or two about.
Thank you, Mr. President.
In your testimony, I find an internal contradiction that is insuperable. And that is that on the one hand you say, and you say it, and you have repeated it many times in the last 2 hours. On the one hand you say, in our office, we don't take sides. You've also said that we did not interpret the agreements between the parties, that it wasn't our function to interpret the agreements between the parties. Yet on the other hand, you interpret the agreements. Not only do you interpret them, but moreover, you reach the conclusion that those agreements were violated by the company. So there's a contradiction between the two things. You take sides on the one hand, and on the other hand, you say you don't take sides, you can't take sides, that it's not my function to take sides. If it were true that you don't take sides, you would not interpret this agreement of February 26th, nor would you reach conclusions about who violated it and who did not violate it. What comment do you have in this regard? Let's see. Distinguished member of the tribunal. It's not that we take sides. We undertake an internal analyses that we evaluate. We don't take those analyses to the dialogue roundtable and expound upon them. We don't do that. But we do have to analyze the agreements. And that is our analysis. But we don't share it with the parties. And when you say that we are taking sides in developing an agreement, we analyze facts. For example, on the 15th, the company said bilaterally with the community that they're not going to be able to hire the topographer because it's very expensive. It's a fact. And therefore, that fact of not hiring a topographer for the community was a failure to carry out the commitment. This is our internal analysis, but I'm not taking it to the debate itself. Not you, but the commitment doesn't say anything about who should pay for the topographer. So that opinion that you just expressed requires an interpretation of the contract in one way or another. And why you don't make that interpretation, you don't express that interpretation at the dialogue roundtable, you do in your testimony, in your written statement, and in your testimony before this tribunal. Yes, because I'm here to expound upon the facts before the tribunal. And in terms of it not saying who would pay the fees in the context of an agreement, in practice, the expenses for implementing an agreement are always taken on by the company. And I can explain to you why. The tribunal is perfectly able to interpret the contract. According to you, it's not a contract. It's an agreement that is not binding at any rate. And I'm not asking you about the content of the contract. I'm drawing attention to an inconsistency between what you say are your functions and what you do in reality, which is to interpret the contract, not only interpret the contract, but also express an opinion about who violated it and who did not. You are taking sides, even though you say that you don't take sides. May I? What I have to note here before the tribunal is that we undertake internal analyses, and we have to do so.
Sir, excuse me, you've already said that, and I think we understand your position in that regard. You analyze it internally, but you're telling us you do not allow those analyses to affect your external conduct. Is that your testimony? Okay.
Exacto.
If so,
Exactly, that is it, yes.
so perhaps we can move on. Anything further?
Yes. No.
Please. I have a sort of a structural question of how decisions get made in the ministry. Now, you testified earlier today that you were up 3 tiers in the bureaucracy. We know there was your immediate boss, who you told us was a counselor to the minister. Now, you've also referred to 3 higher areas of hierarchy: the minister, the deputy minister, and an official who was translated as the counselor. Is that right then, that we go minister, vice minister, counselor, perhaps someone else before we get to the level of your boss? Is that right?
No, what I wanted to say, Mr. President, is that the high-level management,
I'm simply asking facts that you know. Can you describe for me the hierarchy in the ministry?
that's what I want to describe, the hierarchy of the ministry. There's my boss, my immediate superior, who is the head of the OGGS, which is an organ that advises the office of the minister. That's what I could say, and it's in the organizational chart for the institution.
All right, then, so a decision to cease dialogue, a decision to pursue the course that Mr. Leon was proposing, would that be made at the level of your boss or at some higher level?
Eso primero
That would first have to go through my boss and then to a higher level.
Judge in the abstract, how high? Deputy minister, or would something like that have to go to the minister?
tendría que
Well, let's see. It would have to reach the minister.
Now, I had a question very similar to arbitrator Garibaldi's, so I don't think we need to duplicate that ground. But I just wanted to confirm my understanding. It was that as you did this internal analysis of the agreement, you concluded that the agreement did not provide in any way for the reopening of the Laksanga Road. Is that correct?
correcto.
That's correct.
Okay, and further, I'm looking now at paragraph 48 of your second witness statement. You also concluded that the survey was for the purpose of essentially surveying the design of a road. Is that right?
Mr. President, that is my interpretation. It's internal in nature, in connection with the.
I fully understand that, and I don't want to waste your time. I'm just want to make sure that we're clear on what your position is. I had a further point I wanted to check with you, but at the end of a long day, I've forgotten what it is. So I will not trouble you further. Are there any other questions? All right. If not, then we thank you for your testimony. You are now relieved. You can join your team. You can do whatever you want, but you have no further business with us, and we thank you for your testimony.
Thank you very much, Mr. President, members of the tribunal. Thank you for Secretary to the Councilor. Thank you for the councilors, on both sides.
All right. Do we have any further business tonight? Any further administrative business? The witness is released, so he doesn't have to be sequestered tonight. Anything we need to deal with? If
Yes, Mr. President, just
yes, sir.
Mr. President, we have to raise these issues to ensure that
that's
there's an orderly conduct of the proceeding, and they concern scheduling. So we can leave it until tomorrow.
Well, no,
but tomorrow may be too late.
let's raise it.
Thank you. So the schedule is such that we should be cross-examining two fact witnesses tomorrow, and then commence and conclude the cross-examination of Ms. Dufour. We just want to inform the tribunal that Ms. Dufour would have to leave. She has to be back in Lima by Monday. And so we are concerned that we may not be able to complete the cross-examinations tomorrow. That's why we're raising the issue.
Let me ask, would it be possible to shuffle the order of the witnesses so that she comes first, second, whatever is feasible? It seems to me that's in your control.
Which is why we are raising the issue. It's not within our control because we need to decide what happens with the fact witnesses that come before the expert.
All right. And have you raised this with the other party?
No, we have not.
Could we please ask you to do that and give us a report? If you need to get a decision of the tribunal overnight, we can do that. Although we'd rather not. But perhaps you could liaise with the other party.
Happy to do so.
All right. Any other business we need to tend to? Anything on claimant's side? Anything on tribunal side? If not, we will see you again tomorrow at the accustomed time and place.